Hey guys, welcome back to another legal studies video. So today we're going to be looking at the burden and standard of proof in civil cases. By now we should understand some of the basics of civil law, but our introduction isn't complete without a look at the burden and standard of proof. And after today's video, you should have a really good idea of what the key concepts in civil law are all about. So in today's video, we're going to primarily look at the burden of proof and the standard of proof. Whilst this is something that we have looked at before in criminal law, it works a little bit differently in civil law, and there's some new terms that come up that you probably haven't seen before. No stress though, it's actually not that hard. Alright, so the burden of proof is the responsibility of proving the facts of the case. We also call this the onus of proof, and someone always has to have this responsibility in a court case. Now, we know that in civil cases there are two sides. The person who's making a complaint, the plaintiff, and the person who allegedly did something wrong, the defendant. Now, it's always the responsibility of the person who's making the complaint, the plaintiff, to establish that the defendant did something wrong. This means that the burden of proof is on the plaintiff. Basically, because civil law is all about proving that someone's caused harm to someone else, one person always has to have the responsibility of proving this. So this is always the plaintiff, as they're the one who raised the complaint. So what are the implications of this for the way that cases are conducted? You've probably noticed by now that civil law is not at all like criminal law, where it's the police's job to intervene if somebody breaks the law. So in criminal law, if someone shoots you, the police will arrest them and prosecute them in court. But in civil law, the plaintiff has to do this work themselves. Well, not arresting them. But it may be something like a defamation case, where your reputation has been damaged by what someone said about you online. If what they said wasn't actually a crime, the police aren't going to do anything about it. They're not going to arrest you. And basically, it's up to you to make a claim and take them to the civil court. In court, it's also your responsibility to prove that the person wronged you. Now, because the burden of proof is on the plaintiff, it's also not the responsibility of the defendant to prove that they are not reliable. Basically, they don't need to prove they're innocent. It's assumed that they're innocent. It's you, as the plaintiff, who needs to prove that they did something wrong. So in this way, it's kind of similar to criminal law. You're assumed innocent and you have to be proved guilty. So in summary, if someone has wronged you, it's not only your job to raise that problem and call someone out on it, it's also your job to prove your case in court. I know this is a bit of a strange concept, as we're pretty used to the police stepping in for us and saving the day, but that's exactly why civil law is so different, because it's all about disputes between individuals and really doesn't involve anyone else. Now, when we're talking about the burden of proof, we also have to look at the standard of proof. The two always go hand in hand, and it's important to know both for the civil trial process. So the standard of proof refers to the degree or extent to which a case must be proven. Now, you might remember that in a criminal case, the prosecution has to prove the defendant is guilty beyond reasonable doubt. So it's got to be pretty much certain that the defendant did the crime. Well, the standard of proof in civil cases is a much weaker on the balance of probabilities. Sounds pretty wishy-washy. What it means is that the plaintiff, the person filing the claim, has to prove that they are most likely in the right, and that the defendant, or the person they're making the claim against, is most likely in the wrong. I know it's a bit more complicated than in criminal law, but think of it this way. If you're the person making the case, you just have to make the court believe that your side of the story is more believable than the defendant's. If the judge or jury believe you, they'll rule in your favour, as you've proven your case on the balance of probabilities and fulfilled the standard of proof. So unlike maybe having to prove 99% certain that they did it in criminal law, this is more of maybe a 60-70%, yeah, probably did it. Okay guys, that's all for today's video. Let's quickly summarise what we learnt. So we know that because civil law is a little bit different to criminal law, the burden of proof is on the plaintiff in civil cases. In civil cases, the standard of proof is on the balance of probabilities. This means it's up to the person who's making the complaint to prove that they are more in the right than the person who they are complaining about. So what we can take from this is that as the plaintiff, you have quite a lot of responsibility, and basically it's your job from start to finish to prove that someone wronged you. So maybe before you're inspired to file your first defamation claim, think twice, because it really is a lot of work. And did I mention expensive? So that's it for today. See you next time.